we'll go back to questions. We have Councillor Ferry online.
Kia ora, thank
Mr.
you.
Chairman.
Sorry, hang on a second, Councillor Ferry.
Mr. Chairman,
Councillor
please,
Lee.
could I make a point of clarification here as the mover of the motion we're discussing?
Yes.
Mr. Chairman, I'm concerned that the notice of motion is being conflated with the next item. I want to point out it's very important that the notice of motion has nothing to do and will have nothing to do with the Rawene Avenue decision and what actions the council may take in regard to its own decision, which it cannot appeal itself. It's important that the notice of motion is discussed on its merits and that questions and the debate by question or subtle debate by question is avoided. This must relate to the notice of motion up on the board and nothing else. Thank you.
Kia ora, Councillor. I did ask that very question, but as your letter to Phil Wilson is attached to the notice of motion and your request for the two notice of motions very clearly mentions the decision and the concerns around the permitted activity status that was taken as judgment, I guess, by the independent commissioners, that all of the issues can be questioned as it does relate to the information you provided while you put forward your notice of motion. Thank you. Councillor Ferry.
Kia ora, thank you. And this is quite complex, and so I really appreciate the opportunity to ask questions of the staff to sort of clarify some of this. So I've got a few questions here. The first one I wanted to ask, I'm trying to put these in a sensible order. The first one I wanted to ask was a sort of a little bit of a, I guess, an RMA 101 question that I want to get clarified around the way that the RMA, the Resource Management Act, works for decision making for plan changes, plan modifications, resource consents, the way that it is set up at the legal framework in terms of weighting public input and expert testimony. And I think this is, like I was particularly taken by the points made in the I think it was Quite Skies Waiheke submission, and I did read their post around the democratic aspects of this process. And so wanting to understand, progressing something through the RMA, what is the role of the public input aspect of that as opposed to the expert testimony? So if staff could sort of speak to that more broadly, and obviously that relates to this because one of the things we've had staff bring up is the evidence base that we need for a plan change for prohibition, and they're concerned that we would not reach that evidence base. So how does public wish for prohibition play into that equation and the way that that works its way out? That's something I find quite key to this whole issue.
Okay, through the chair, I might have a go at this, and then if need be, I'll call Karina to give me a hand as well. So if we just walk our way through the progression phases first, and then we'll talk through the post-notification phase. So just turning to the preparation phase, staff need to firstly understand the planning issue, so there could well be research which is required. That research could entail a consideration of information from how the current approach is performing, looking at existing consents, looking at existing changes within amenity levels, understanding what the existing noise environment is, understanding from those that experience the planning issue, understanding perspectives that might come from iwi, building all of that information together, and that is information that is coming through. Then we go through the Section 32 preparation phase of considering what the options might be to address the planning issue and putting forward what we consider to be the most appropriate approach. When you're going through that phase, you're starting to pull together the more definitive information, and you're starting to pull together the expert evidence information to support the most appropriate approach. So you're narrowing as you're going through time and strengthening the quality of that information. When you get to the notification phase and you're out for submissions, you're getting a range of submissions that are coming in. You're getting submissions from lay members of the public, you're getting submissions from particular stakeholder groups, you're getting submissions from iwi, and you're getting submissions which have attached to them expert evidence which has been put forward from those that have been hired in support of the submitter. The 42A report, which is the planner's recommendation report, to consider what was proposed and then consider all of the learnings that have come from all of the submissions that have come in. That phase in turn is often supported by further research which is undertaken, and in many cases the commissioning of further expert evidence to consider that information that's come in. That then results in recommendations for how provisions might change at hearing through evidence which is given. Often there's an opportunity for rebuttal evidence to be given by others and for further learnings to come from that, and in many cases experts who are involved in the process to refine, sometimes to come together through expert conferencing. The way in which the commissioners then actually consider the information in front of them. They're looking at what is the expert evidence, and they're looking at evidence. How do they arrive at what is expert evidence? That comes down to a couple of factors. One is going to be qualifications, and the other is going to be experience in dealing with the particular planning issue. There is not a law or a rule or a guide or anything which stipulates exactly when something becomes expert evidence. That's what the commissioners consider from the information that's coming to them. It is really important to say that the final decisions from the commissioners come from all of the information that they receive, regardless of whether it is lay submitters' information of just photographs that have been put in or records that they've kept, or whether it is those that are experts with their noise monitoring equipment that have been calibrated and meet the exact requirements, etc. So I hope that sort of traverses through time the way in which the information / evidence / expert evidence is considered.
Yeah, thanks. I think that is helpful. I have a follow-on from there around. So one of the emails I received was from the cartoonist Chris Lane, and he did an interesting comparison between roosters not being allowed in the urban environment, which I believe is under our animal management rules, is not necessarily an RMA thing, and helicopters. And that sort of got me thinking about, you know, if we had a scenario where we said, where we had, you know, 90% of the public through rigorous, you know, I don't know, surveying, polling, we held a referendum, whatever, who said we don't want any more houses that are painted blue, but we couldn't meet the evidence threshold for prohibition from houses that were painted blue. Could we progress that through an RMA process?
Through the chair.
And I blue's my favourite colour, by the way. It's not a political statement on the colour blue.
As it turns out, for landscape reasons, colours of houses is actually something that, from an RMA point of view, does get considered. Yes, there is, as part of preparing those types of plan changes, the need to understand the community perspectives on those colours, and also, in that type of case, what the experts have to say, and in that case it would probably be landscape architects that would give a view on that sort of thing. And then it's a consideration of, well, what is the right type of approach to introduce into the regulatory document through the plan change? And that approach could range from prohibited activity status all the way down to permitting any colour provided it's not blue or is blue. So you have to determine the activity status with an eye to your understanding of how it can be managed, what the different mitigations are that people could take. Is it a matte finish? Is it a gloss finish? What's the extent of protrusion above ridgelines? Is it a house on its own compared to alongside a number of other blue houses? So you use all of that type of information to arrive at how well it's understood, how it could be managed. Can we restrict what we consider to be relevant as part of decisions on these types of applications that can come forward? And you might reach a conclusion that, yes, we do understand this well enough. It is in a situation, though, that in some situations we may wish to decline an application and ask that they don't choose that colour. So you might land it as a restricted discretionary activity. But as we mentioned earlier, if you were to form a conclusion that it should be a prohibited activity, then you must also have found, as most appropriate, that in no situations could anybody have their house painted blue. So the house is all a long way away from another house and not seen by very many people. It's a very pale shade of blue. It's a matte finish, not a gloss finish. So you've got to go through all of those types of permutations to arrive at that conclusion that it should be prohibited, and in no instance of any way, shape or form can anybody make an application. And so for colours of houses, I don't say an absolute, but I would be surprised if there are prohibited activity statuses associated with particular colours. They're probably looking at as tone differences or a colour spectral approach, which is perhaps the opposite of what the tussock background might be, or something like that.
So my point wasn't really about whether we could do it for prohibited. It was more about if a large portion of the public said they wanted to prohibit it, what weight would that have under the RMA for consideration of making it a prohibited activity? Because I totally get and I agree that we shouldn't have private helipads in residential areas. What I'm concerned about is whether this is the right tool to achieve that outcome, or whether we're setting ourselves up to fail. That's what I really want to understand here. And so the fact that we have a high level of public support for it to be a prohibited activity, and I think that's probably the case, that there is a high level of public support, doesn't necessarily, this is what I'm trying to understand, does that help or is that irrelevant? What part does that play in us reaching the threshold for it to be considered a prohibited activity? Does that play a part? How big compared to expert testimony? If because the staff advice is that we might not be able to get expert testimony to say that it would never be appropriate to allow a helipad. That's what I'm trying to understand.
If I could turn your attention to the memo, and attached to the memo is another memo, which came through to the Planning Committee, I think, in December 2023.
2023, yeah.
And within that, there's a subsection on page 5, which deals with the case law associated with prohibited activity status. And that references that Coromandel Watchdog decision that I spoke about earlier, and lists a number of clauses there where for that particular case, the judge considered that there could be grounds to be able to apply the prohibited activity status. Now, it's not necessarily to say that if you meet one of those grounds, you therefore automatically can have it, because there are considerations within that. And so the examples that have been given there are not necessarily all of the examples, but I'll go on. So there is one clause there which is where it is necessary to allow an expression of social or cultural outcomes or expectations. And in the judgment, it says, where it is necessary to allow an expression of social or cultural outcomes or expectations, prohibited activity status may be appropriate for an activity such as nuclear power generation, which is unacceptable given current social, political and cultural attitudes, even if it were possible that those attitudes may change during the term of the plan. And so, yes, there is a criteria there around social norms, social expectations. The example perhaps which has been given illustrates the degree of extreme nature of what those social expectations are. But you're right, it would be a factor as part of the research phase and the consultation phase and building towards what is considered most appropriate.
But is it fair to say, sorry, Chair, I know I'm being a bit long-winded and I do have some other questions that are different. Is it fair to say, though, that it would be unlikely that that reason around social expectations could meet the threshold for prohibited on its own? Like, it's likely that you would need some other grounds, or is that, I mean, obviously nuclear power stations is a pretty extreme example.
Councillor, I think maybe, to paraphrase you, are you trying to say when the independent commissioners sit down and look at a prohibited plan change so widespread, and the officers are saying we do not currently have any experts that would back us up, are you saying what's the likelihood of the independent commissioners leaning on the massive public opposition and maybe in political opposition to helipads or helicopter movements? Is that too hard?
Yeah, I guess so. Yeah, I guess I'm trying to tease out here if we can't find expert evidence, or the expert evidence is, potentially knocked out by other experts, because that's how that process works. How much weight would support for prohibition have? I'm just trying to manage some expectations a little bit and understand that, because my understanding of the RMA is that it's not really a democratic process in that way, but I'm wanting to understand that from staff who have dealt with it a lot more than I have.
Perhaps I could mention one important factor in this particular situation is that generally there's a principle in the Resource Management Act that you have the minimum level of intervention in terms of regulation to achieve the outcome you are trying to get to. And so
right.
While you might have some, a section of the community saying, this is important to us, if you can achieve what their concerns are via a lesser amount of intervention or regulation, then that's generally what you're trying to achieve. And so you start off that process when you do your Section 32 analysis. That's what you have to go through that process. You're, as I say, you're always trying to achieve the minimum amount of regulation to achieve your outcome. So
that's helpful. Thank you. So that helps with my next question, which is around if we do, and I guess what I've been hearing particularly from Megan's comments is that if this passes today, then actually there's more work to do, and also what Phil's outlined in terms of various reports and stuff like that. This is likely to need to come back to us to progress further and to be nuanced. So what I'm wanting to understand is it possible through this process to put in or to initiate work on a plan change for prohibition, but with a fallback position of non-complying if prohibition can't succeed for the reasons that we've already discussed? Because I don't want to see a situation where we put all our eggs in a basket that can't succeed, and then we end up with nothing, when we could potentially split our eggs across two baskets, or have another basket that the first basket is sitting within or something in case it fails. Is it possible to take that kind of approach with these processes? Or does it have to be prohibited or non-complying?
Phil and Karina just discussing who's answering that one.
Thanks.
Yeah, through the chair, I think the important thing is what are the milestone steps in reporting back to committee to consider what the research has found and what is considered to be most appropriate to proceed. And probably one of the important milestone points would be the endorsement of a draft plan change to go out to statutory authorities for iwi engagement. At that point, there can be that consideration of whether it is a blanket prohibited activity, whether it was the fallback non-complying activity, or whether it was a blend of the two, either through standards or through mapping approach to identify where it should be split.
That's really helpful. And so that would be a point at which, for example, and Alex Bonham from Waitemata asked me to raise this, might, for example, look at, rather than the, I think it was 250 metres we've been talking about, might look at 100 metres, for example. Would that be the kind of part of the process where we could capture that?
I think, yeah, there are quite a few factors that could actually go into how do you manage helicopter landing pads on private residential land. And so your separation factors would be one, perhaps noise attenuation devices which are designed on site. There could well be other things as well, and that's why it is important to actually go through that research phase, that public engagement phase, understanding from experts what their views are, in order to be able to consider the options, identify what is most appropriate, and as Peter Vari said, to actually look at what is the least interventionist approach available to still secure the outcome of the regional policy statement, the amenity values, the recreation values, etc.
Okay, and supporting this notice of motion starts all of that process, yes?
The wording is kind of different in this one, where it says initiate a plan change rather than prepare a plan change. So that's an issue.
Yeah, normally there have been recommendations such as for natural hazards, which was around request staff investigate the preparation of a plan change to strengthen the unitary plan's management of natural hazards. That's the type of resolution that I've seen where the flexibility is still there to actually find what is most appropriate.
Thank you.
Okay. I have two other questions, Chair. Sorry about this. I've been reading a lot of stuff and trying to get my head around it. So the other thing I want to understand here is the relationship between, so we have two notices of motion and then we have the item 11 resolutions. The notice of motion for Hauraki and Gulf Islands, and I'm sorry, I know but I want to talk about all this, how it all fits together. Does that impact, would that impact on the plan modification that's already underway? I know we had a question before about whether the minister potentially, in terms of his comments around no more plan changes, could withdraw it at this point. But this is a different question. This is what impact the second NOM would have on that process that's already underway.
Partially it would depend on timing. The current plan modification is recognising that it's a restricted discretionary activity to have helipads, and so it's changing the assessment criteria and the standards to make sure that the NZCPS and elements of that are considered when an application comes in. So it's attempting to change, but not change the status, but change the way a helipad is assessed. The notice of motion would mean that would change, and it's a matter of timing, I suppose, is the short answer. But we would need to withdraw it because you couldn't have the two things running together. And the second element is that if the Minister Bishop's proposal goes ahead, then it's more than likely that we would have to withdraw that. Okay,
thank you. And then, so finally, how all these resolutions potentially can work together, because I think, and I think the Chair's said it, I think there's general agreement we want to make it a lot harder, if not impossible, to put private helipads in residential areas. It's just about how we get there. So if this passes and the resolutions on item 11 pass, are they in conflict? And how will staff respond to that? Because my reading of it is they're not, but I want to check that.
I'll draw your attention to item 11 and the recommendation that there is a report back on the outcome from the declaration proceedings. I think there is a decision point about whether to proceed from that point onwards. It could well be that we are successful with a declaration if it was filed and that it is found to be non-complying activity, and that may change the approach to moving forward, whether it is a plan change that strengthens that non-complying approach or a plan change that looks to strengthen that further through having a prohibited activity status. There's a decision point, I suppose is what I'm saying, for whether or not there are any modifications made to previous resolutions.
Okay, so if we vote through this one and option D in 11, it's, staff will start
Point
to
of
work
order,
on.
Mr. Chairman, why are we talking about item 11? We're meant to be talking about the notice of motion. This is going on for over an hour. It's ridiculous.
Yes, Councillor Lee, and there are questions to be had on this, how it relates to the others, and because the letter to the CEO, where you put in both your notice of motions, mentioned the issues we have, they're all related. So we are talking about a pretty big decision here, so we just need to make sure we get it right, because, and that's what I assume committee members are doing. But I will go on to Councillor Bartley now. We've got a number of others.
Thanks, Chair.
Thank you, Chair. I want to ask questions on the NOM, in particular around prohibited activity. And so my understanding is it should be used only when the activity in question should not be contemplated in the relevant place under any circumstance. That's my understanding. And the example given, I read, was nuclear power generation. But it is an activity that can happen, right? Like if you had a helipad in a residential area that was, say, on a cliffside and you're that rich that you have no neighbours, it would be something that could be permitted or allowed.
Through the chair, earlier on I was giving examples of where I believed that there were sites that could be able to have helipads and have the effects of that managed through conditions to the point that it's no longer an adverse effect. And I raised that on the basis that if there was a blanket approach to the application of prohibited activity status, the bar which would have to be crossed is that in no cases could anybody make an application for a resource consent. And if it was found that there were some locations of where it could be managed, then that would be making it difficult to achieve the outcome of the plan change.
Okay, so how realistic is it that this NOM will achieve what it's trying to achieve to get this outcome for what the public are raising?
My advice is that the most appropriate approach is non-complying activity status, because it recognises that there are some instances of where it can be managed, and that if we were to progress in a prohibited activity plan change, it might be difficult when we reach that draft plan change stage to present to you a draft plan change which is, from an expert evidence point of view, supported.
Okay, and how much again would it cost if this was to happen, if we went down this avenue? What are the costs?
I think I mentioned earlier that if it was to be able to be supported through expert evidence, and it was to make it through to notification, and it was to then go through hearings, that to get to the end of that hearing stage itself, probably in the order of about $1 million, to then be able to go through and the appeals after that, potentially up to about 1.5 million.
Okay, so is it fair to say it's a $1.5 million risk for something that we already know what will likely not win?
Yes, it is a risk.
Thank you.
Thank you, Councillor Bartley. Councillor Walker.
I've just got a few very quick fire questions, Mr. Chair. So you mentioned those properties in, was it Cape? Sure. They're residential properties, that's correct? So
correct.
is it anticipated under the unitary plan that you could have subdivision there and you could have a high level of density?
That's right. I think those particular sites were single house zone, and so yeah, on the basis that they were over 1,200 square metres, and from recollection they were, yes, they could be subdivided.
Okay. And prohibited activities, I'm assuming, anticipate the zoning allowance of an area of land?
And this is where the research and the work would need to be done to identify what are the parameters within which the prohibited activity status could be considered most appropriate. And as I said, that could potentially be through a mapping approach or through standards.
And the other question I've got just goes around experts. I'd be correct in stating that experts could be drawn from anywhere in New Zealand and conceivably overseas as well. So how large is the pool of international experts on helipads? Quite significant, I would imagine?
I think you'd be looking at noise experts per se,
Okay.
who have worked within a planning regime.
But there's plenty of them out there. Okay, that's great. The other question I've got just goes to how a prohibited activity works when there are locations that are available that are suitable for an activity. So, for example, you might not be able to have roosters in a particular location, but there are locations where you can have roosters. And obviously the unity plan directs people to that location. Does that concept apply here, where the public at large may not want to have helipads all over the place? Goodness me, how many helipads could we end up with? I don't know. I'm assuming a very, 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 very large number, in which case, why wouldn't you have a status to prohibit them and direct them to particular locations when those locations are in proximity and available?
And that was my last answer. So if there was to be work done on a plan change which was looking at the opportunity to utilise either or both of non-complying and prohibited activity status, is that it might well be done in such a way to make very clear the locations where there should be no applications received at all, and the locations where, on the basis that all of those effects could be managed, then an application could be received. Now, non-complying activity status, of course, will need to be supported by very clear objectives and policies about the way in which it could be allowed to occur.
So what follows then in respect of a prohibited activity is it may well have a significant amount of merit in the instance of helipads. Otherwise, they could be everywhere, could they not? All around the coastline, in many locations.
Again, we need to actually look at what is that least interventionist approach to manage the outcome, as well as ensuring that we've met those legal tests around prohibited activity. So I don't want to get drawn too much into what is the respective balance between those two activity statuses, or indeed whether they both should be utilised. My professional advice is that a non-complying activity status is the best mechanism, supported by very clear objectives and policies.
Thanks, Councillor. Councillor Watson.
I wasn't going to ask a question, but seeing you asked me, Mr. Chair, no, just a very quick, and it's a kind of general one. Obviously we do, and it goes to this notion of cost. We do a number of plan changes, many of which are council initiated. So in terms of cost, I'm assuming, they're all pretty expensive, aren't they? Generally speaking, or there are numbers that are as expensive or more expensive than what's anticipated here.
Yes, plan changes by no means cheap.
Okay, thank you. So it's not just this plan change, it's plan changes generally. And the second question, and it might not be your place to answer this, but obviously a significant component of it is this mail out. I think someone was mentioning 400 grand or whatever. I'm just wondering, might be up to the director to answer this. given that significant cost, given that a stamp's $2.90 now, is there any process underway to make that more cost effective? We send out rates bills four times a year, for instance. Is there any work underway there? Because that has been an element that's been brought up here, Mr. Chair.
Through the chair, look, a really good question. We've been talking about this for years back at government, saying, you know, this requirement to physically serve letters on any particular adversely affected people. Sometimes that's just a few people around a site. Other times, you know, like in this situation, it could be almost everybody or the whole residential, neighbourhood. So it all depends on that. But look, we've talked to government. We do think there might well be a change coming in the new kind of resource management bills, but we don't think anything will change for this particular, if this goes through. In terms of, say, combining it with other mail-outs, we do try and do that, but that all becomes a matter of timing. So we will look at that kind of thing if this goes through, yeah.
Well, that's good, because a big chunk of cost could be removed. Thanks.
Thank you, Councillor. Councillor Williamson.
Yeah, I'm in desperate need of help. I can't come to a conclusion every time I read Mike's notice of motion. I'm in favour. Every time I read what you've put in 11, especially doing D, it seems to me that might actually achieve what Mike's notice of motion does, but do it quicker. So can I get, and a lot more safe in terms of the outcome. So if you're a poor, simple soul like me who only wants to do one thing, and that's make it quite a lot harder for people to get the right to have a helipad in a residential area, but not exclude anyone, because we've got one out in Mellons Bay up on a cliff top, which is on a 4-acre site in amongst houses. Now, 4 acres is a big piece of land. It's cliff top on the outside, and he comes and goes from the ocean. Neighbours have said they don't even know when he's coming and going. And I'd hate to have a blanket ban on a site like that. But I too would not like to have a helicopter permitted beside my bloody house at night landing. So I want to know from officials this. Is it better we go down the route you're advocating in D, in 11, because I've read it so many times and I'm confused. Maybe I've got a small brain. Or would we achieve the goal of trying to reduce the number of helipads in private sections in Auckland? Would we do it quicker if we vote for the notice of motion, quicker if we vote for 11, or can both stand together?
So if we turn to item 11, and I do understand that this is not item 11, we've got D, which is seeking that we initiate the declaration proceedings. The importance of that, as I mentioned earlier, is to remove that uncertainty in the community about what their rights are, given that we have a staff interpretation as non-complying, but we have a recent commissioner decision on behalf of council that it's permitted. The importance of that is that it can be lodged very quickly. It also sends a very clear signal around the way in which we actually treat these applications. Hopefully addresses what's called a gold rush effect of people who see that there is an opportunity to get in and obtain consents as permitted activities, and enables for the court to actually provide clarity for us against the other part of D, which was the preparation of a plan change. So that there is a learning as we're in preparing that plan change from the court proceedings. Now, when it comes to the
Can I just say that I've currently got a big list of things and ticks and crosses in both columns. Yep. And they both add up to a similar number at the bottom, and that's why it's a dreadful position to lie in. I'm seeking from you, just take the simple soul like me, if I was trying to achieve as quickly as possible and as cheaply without courts costing millions over the years, an outcome of restricting quite substantially the number of times people can get a permit to fly into a private residence, but not ban outright at all, I need to know from you guys, would it be better to follow 11 Or would we be better to do Mike's nom, or you're better to do both?
My recommendation is to go with 11 on the basis that it keeps the current approach that we see the unitary plan applies. And so all of the provisions that are within the unitary plan continue to perform as we see that they should. And therefore we're not needing to actually change tack a lot in terms of preparing something which is substantially different, because remember, a prohibited activity status, the preparation phase is onerous,
Right.
in order to secure that most appropriate outcome of prohibited activity status, knowing, of course, that the least interventionist approach is the principle to follow. Whereas item 11 has immediacy with respect to the declaration to the court. It's got consistency in the way in which the unitary plan continues to be administered, and it provides options as well, should the outcome of the court process not go as we see the plan is interpreted at the moment.
Can you just tick the last little box for me then? Which is going to have the most money have to be spent on it by everybody, by both council and lawyers and the protagonist?
Item 11 provides an opportunity to spend the least money.
Okay, thank you.
$200,000 was in the table.
Thank you. You don't have a question now, Councillor Turner, just a comment. Okay, Councillor Filipina, and then Chris, Councillor Darby.
Kia ora koutou, and apologies for not being there, Chair. Also, kia ora koutou to our staff. I'm going to ask a question on 11, knowing that we are discussing the notice of motion. My pātai on the 11 is in regards to the comment from around the Rawene address. Now, do you know if there's any appeal, Phil, that has happened from the neighbours in regards to that? Can you answer that question first?
Yes, an appeal was received.
Can you also then, for me, wouldn't it be better at this stage anyway, of either being part of that appeal or assist in regards to that prior to doing a plan change or start the process for one?
Council's the what's called the respondent. So
Yeah.
on the basis that the appeal's been received, there isn't a choice to be made. We have standing through that process with the court.
So as a result, it could be better to be part of and with the appeals that have been received at this stage.
There are potentially two courses with respect to the court. One is to, as the respondent, be involved in the appeal and the appeal only, and seek through that appeal process that there is, not sure what the correct term is, but an interim decision which is made with respect to the activity status itself. The second option is to maintain standing in that appeal process, but also serve separate proceedings in the court, being the declaration.
Kia ora. Thank you, Chair. Kia ora.
Thank you, Councillor. Councillor Darby, and then the last question will be Councillor Henderson.
Thank you. Phil, and possibly others as well. Just in terms of the notice of motion, you've heard me talk about wanting to make sure we took a holistic view beyond the places where people live. At the moment, it's now changed to residential areas. If that notice of motion went through, would you highlight, if there were, unintended consequences for other zones? You know, if there are things that you identify through working up a plan change with a prohibited activity status, and that creates unintended consequences on other zones, do you feel like you've got the freedom to address those in a more holistic plan change, or does it need to be more prescriptive in the wording here today?
If we've got a resolution which talks to a plan change relative to helicopter landings and takeoffs from residential properties. My view of that, and setting aside the activity status aspect, is that we need to understand all of the issues that are at play.
Sorry, just repeat.
All of the issues which are at play. And that may well be extending beyond the residentially zoned land in those instances where there are coastal marine area implications or open space implications of Esplanade Reserve areas. To guide that type of work, we of course will look to the regional policy statement itself as well, and looking at what's called the horizontal consistency across the plan, to check whether there are any of those consequential changes that we need to make. We also need to consider what the responses are to the plan change, and how people look to still be able to undertake the activity, and would they undertake the activity in different locations to a greater extent as a result of managing it more strongly in some locations. And so, yes, they're all factors that relate to managing of helicopter landings and takeoffs in residential areas. And I would see that we need to come back as part of the preparation phase to advise committee where we do see there is a need to go broader than perhaps what the resolutions say.
Okay, so the way the notice of motion is worded at the moment, it's very human-centred, but I'm expressing concern about not being able to capture the natural environment effects or the cultural effects, because at the moment this is about the effect on people. That's why it's focused on residential, which is in my eyes too narrow. But you're saying that in the work you would actually you would have room to explore wider. Okay. So the other part, going back to your recommendation, and your recommendation under 11 talks not about residential areas, but it talks about in residential zones. There's a slight difference there because there are zones where people live in Auckland, particularly vertical living or denser living, which are not necessarily residential zones, the town centre zones, the metropolitan centre zones. So that we don't need to fuss over that. That's a bit like a reply to the former question. You'd pick that up. Okay, happy with that. Then we talk about activity status. It's one or other. But of course, the objectives and policies are the critical part that sit under the activity status and how they are worded. Do you want to just take us through your recommendation non-complying with really strong objectives and policies versus prohibited? My reading of it, from my experiences, you can have extremely strong objectives and policies sitting under non-complying, which take that activity of, say, helipads so close to the border of almost being prohibited. Correct? Am I correct in that regard?
Yeah, that's right. And it comes down to the choice of verbs that are used. And avoid is the verb which tends to be used to manage things in the strongest way. Certainly when you've got a prohibited activity status, that would be the verb that you're using. When you've got a non-complying activity status, you're probably still using it, but setting out the circumstances in which it still might be okay to occur.
And so the real test is if it was non-complying, is really focusing in on the objectives and policies and wording those up, which they are not currently worded. Airtight, watertight, cannot drive a bus through it, let alone a helicopter through it.
Yeah, that's right. And let's remember the way in which our residential zones have been prepared. They have not been prepared on the basis of anticipating this particular use. So we do not have objectives and policies in our residential zones that clarify how we treat private helicopter landing pads.
Thank you. Councillor Henderson.
Yeah, thanks, Chair. Just a small one. Just want to clarify the projected cost of around $1 to $1.5 million. Is that part of an existing budget somewhere, or would we have to reprioritise that from somewhere else? How would we find the money?
There are existing budgets that we've got, which we use for our council-initiated plan changes. We have a work program where within that we need to prioritise what we can proceed with, and that relates to both staff capacity as well as the financial ability. And so, yes, it would need to come in on that ladder of prioritisation.
And presumably you wouldn't be in a position to give any advice on what might fall down the list yet, correct?
And one of the issues that we face is the actual staff availability. A lot of our work does get driven from the notices of requirement and the private plan changes and the plan changes that we're required to do by central government. The number of our plan changes that we initiate at our own making is very small.
Thanks, I appreciate that. Thanks, Chair.
Thank you. Last question, Councillor Fletcher.
Well, thank you. And I think mine probably flows on a little bit from the question that we've just had, because we all agree that planning is complex. And I can't help but feel today's Groundhog Day. It could be back to 2023. We're having the same discussion around the same issues. And it's caused some reputational damage to Auckland Council. That is the reality of the situation, that I think a majority of people are really unhappy about the lack of clarity around this policy. So my question to you is, would we have had agenda number 11 on the agenda today if it weren't for Mike Lee's notice of motion?
I think the recent resource consent decision raises a really important issue in its own right in terms of the interpretation of the plan and what other applications come from it. And so the staff interpretation of the plan, as I've said, has been non-complying and has been non-complying right the way through. To have this decision that sees it as permitted is a very different activity status to non-complying. And the signals that sends with respect to others that may seek to come forward and do helicopter landing pads on private residential sites are things which create a planning issue, which in my mind would have still generated a report coming to committee.
But as we've just heard, I mean, lack of resources, lack of staff time, lack of all of these things can often mean that good things don't happen. I want something to happen today, and I've listened very closely to what you've told us about costs, expert evidence, planning issues. I've heard from Megan Tyler saying she's not going to thwart democracy. If it's the will of this committee to get this done today, that officers will work constructively. So my question is, by supporting this notice of motion, will it provide some impetus? Will it provide some of the releasing of the resources required to get something done so we're not sitting here again in 3 years' time having another Groundhog Day? Because nothing seems to have moved quickly on this. And I can well understand the frustrations that our community are feeling with council looking to be ineffective.
Through the chair,
Phil, did you want, Megan was about to answer the last question and part of
Sorry, I was actually directing it to Phil, but
They're all good, not at all. Look, just wanted to clarify, just to your previous question, Councillor Fletcher, on the day that we heard about the release of the independent hearing panel decision on Rawene, the chair called me about, so, you know, we've got a policy and planning committee coming up, what do we need to do? So we started that conversation on that day. So as against to the NOM itself. Look, and just in terms of budgets and action, as you say, Phil is right. Of course, this comes on top of a bunch of everything else that we've got on our plate, but clearly this, whichever way it goes, is going to be a priority for this committee. You are effectively telling us it is. So we will get on and do it. It might be, though, that other things, well, it will be that some other things will slow down, will stop. As a result, this is clearly going to be a priority for you.
Did Phil want to add further to that?
No, I was going to reiterate exactly what Megan Tyler said, that as a planning issue, it is a significant planning issue for us to address. Where it sits on the priority against other changes that are looking to make incremental gains, this is a pretty significant issue to be able to be making sure we're clear to the community on.
I guess it does come back to leadership and trying to use our votes in order to see progress.
Thank you, Councillor Fletcher. Now, we've exhausted questions, and based on everything going around and around and wanting to get an outcome, and also now speaking on item 11, I do have an amendment that I will put around the room for everyone to look at and have a break. We'll put it up on the... yes, and Councillor Dalton is seconding, and we can discuss it. I'll sit down and talk to Mike about it. No, once the motion is on the table, I've asked legal about this and everything, so I will read out what it says and then we can have a break to discuss it. Basically what it says, and I won't speak to it right away, but we will look to it, is that, do you want to put it up on the screen? Sorry. Yes, no, we are sending it around in hard copy and everyone can take a break. Yeah, the two things I've said is we'll all have a hard copy, and so this will be my speaking turn when I get to it, but it's for the public. It is note there have been recent government announcements suggesting council-initiated plan changes will be limited. Note the advice from independent experts presented in December 2023 that it would be difficult or impossible to establish the helicopter landing areas in all residential areas. C, request staff seek a determination from the Environment Court through the resource consent appeal process or a declaration from the Environment Court on the activity status of private helipads, as referred to in item 11, that deals with the current consent that is being repealed right now. And then it goes into, this is trying my best to align with Mike's nomination, notice of motion, but get something done, which is a non-complying activities in general with targeted use of prohibited activity status in sensitive areas. I will remove such as coastal properties based on advice from staff, but that would enable a far greater ability to use prohibited status without it being blanket. And then E. So we'll go for a 5-minute break and everyone can read what is on the...
Can you just assure us before we break that this is not a direct negative to the original notice of motion?
Yeah, my understanding is that if it's an amendment by replacement, it's not a direct negative. It doesn't say do not do prohibited. It gives options to do with prohibited with it. We can have a 5-minute break and discuss it. Otherwise, it's only been prepared during the meeting. I've adjourned the meeting. Thank you.